Welcome everyone to the second session of Anarchy and Law Reading Group. Last time we discussed the very basics of how arbitration mechanisms in a free market could replace a centralized body of law, that is the state. We also criticized the state's justice system on the problem of calculation. In this section, we'll be concentrating more on what justice is and how and the topic of crime prevention and how it is related to public property. In the Andrew, I think I'm getting a feedback from you.
Okay, hold on. I'll get some headphones.
This is a where is this feedback coming from? Is anybody else getting the double voice? I mean, like what I'm saying is getting repeated after quite a few minutes.
No, not really.
It's happening for me only. Why? Oh, sorry. So that YouTube link was open. Sorry. Sorry about that. Andrew,
Okay.
it was not you. Sorry. Another tab that YouTube link was open that I shared. Anyway, so yeah, so in the discussion group, I asked what is the difference between libertarianism and basically market anarchism, and I did not get any satisfactory reply. But there is a difference. They are not the same thing. You see, when we're talking about justice, we are leaving the realm of libertarianism as Rothbard saw it and entering the realm of market anarchism. Libertarianism is concerned only with the ethical use of force in society. It has formulated what it considers to be the most consistent principle in this regard, that which we call the non-aggression principle. As the saying goes, my right to swing my fist ends where your nose begins. If I really punch you, the libertarian logic will say that it was ethically wrong to do so. Most people agree to this, but libertarians use this analogy and apply it everywhere in every aspect of our lives. But libertarianism doesn't talk about justice. It doesn't say how much about. It doesn't say much about what is justice and after its ethics has been violated. Using libertarian principle, you can conclude that defensive force is ethical, and you can also conclude that taking restitution from your aggressor is also ethical. But the principle itself doesn't say how much of restitution amount would be just. If you steal 10 rupees from me, are you now under lakhs of rupees of restitutive debt? Am I going to be demanding that much restitution, and will that be considered justice? Market anarchism is the idea that market institutions can handle these spheres of activities better than governmental institutions. There isn't anything particularly libertarian about it, except that they are consistent with libertarian principles, while the state isn't. But we also saw in the last podcast, David Friedman, he wrote about how these market institutions may even result in laws that are not precisely libertarian. Uh, Libertarians support market anarchism because they consider it to be the best option for protecting people's life, liberty, and property. Sure, it would be amazing to live in a society with no conflict and no one breaks the non-aggression principle, and when they do, they offer restitution themselves. But if such a society existed, there would be no need for arbitrators. Conflicts are bound to exist, and we all have conflicting goals. Many of these goals are mutually exclusive. Market anarchism is basically libertarianism being real. And when we are talking about restitutive justice, we need to understand the economics of it, which is what Morris and Linda Tannehill do in chapter 4 of this book. The system that they describe is almost the same as that we discussed in the last podcast, where we read Rothbard and Friedman. I'll be assuming that you have listened to it. I will also only be talking about the additional insights of these writers in this podcast. So let us discuss justice. Is justice the concept of eye for an eye? If so, then what is the difference between justice and revenge? If you think about it, the concept of justice is needed when someone destroys something of yours that you value. That is there is a destruction of property or destruction of value for the concept of justice to be talked about. We can differentiate between justice and revenge by using this concept itself. The Tannehills consider eye for an eye as revenge because it consists of destruction as a reaction to destruction. If you take out my eye, I lose something that I value, and if I take out your eye in return, I would not be doing justice. That would be revenge. There is a net destruction of value in revenge. After revenge, both people are worse off. The criminal has been punished, but the victim's condition has not improved. From the chapter, the present-day penology no longer makes such demands. Instead of an eye or a tooth, it takes the criminal's life via execution, or a part of his life via imprisonment, or his possessions via fines. As can be readily seen, the principle vengeance is the same, and it inevitably results in a compound loss of value, first the victims and then the criminals. Because destroying a value belonging to the criminal does nothing to compensate the innocent victim for his loss, but only causes further destruction, the principle of vengeance ignores and in fact opposes justice. So, end quote. What is justice? Justice would be compensation to the victim in proportion of the value he has lost. Under restitution-based punishment, the criminal is declared to be under debt to the victim. Once declared to be in debt by an unbiased arbiter, force can be used to extract that debt. This way, the criminal is punished and the victim is also compensated. Moreover, we find restitutive-based justice system gives the criminal a chance of rehabilitation as opposed to what the state provides today. State prisons are usually called rehabilitation centers, and their language tends to use that jargon as much as it can, but we can easily find that the opposite is true. Government-run prisons are little more than schools for crime, where young first offenders are caged with hardened criminals, and there is no incentive or opportunity for rehabilitation. Government-run prisons are centered on the concept of revenge rather than justice. The concept of prisons can also be derived from restitution as well. I could not compress this section from the book, so I will just read it out loud. If the aggressor had the money to make his entire reparations payments immediately, or could sell enough property to raise the money, he he Andrew can ask a question if you want to ask right now, or I can if you want to add anything, you can go add right now.
All right. I think the concept of an eye for an eye, tooth for tooth does not resemble what it originally meant. It came from an Old Testament Jewish court tradition, and
Okay.
the basic they didn't actually take eyes and teeth. What it meant was that you can't ask for more recompense than you are due. In other words, if something cost you $100 of theft, you don't have the right to take $1,000 of the other person's property. That was the original meaning of eye for eye and tooth for tooth. And it wasn't intended to be vengeance. It was intended to keep a balance in between the level of the crime and the level of the recompense. And recompense was handed out in these traditional Jewish courts. Just so they put that in.
Yeah, I did not know that. I think the meaning has changed a little. I mean, from to exactly the literal meaning that taking eye for an eye. But yeah, I think the authors, I think, are using it in the meaning of revenge, that you destroyed something that I value, I'm going to destroy something, or I'm going to get someone else to destroy something that you value. So I think the
Well,
authors are using it
that actually,
in this sense rather than
the original sense actually seems to
proportional.
go along with what the author is trying to get at. Instead of being opposed to it, it actually sounds the idea of proportionality of
Yeah, they talk about
crime
proportionality
recompense.
later on,
Yeah,
but yeah.
that was what the original intent was. So I'm sorry, I didn't mean to interrupt. Please.
No. Sure can. Actually, I was prepared this to get some discussion started, but like I'll uh, keep on reading unless someone has something to add. They can surely go in and add. So, okay, I'll read from the book now. So the concept of prisons, yeah. So if the aggressor had the money to make his entire reparations payment immediately or sell enough property to raise the money, he would do so and be free and be free to go on his way with no more than a heavy financial loss. Situations of this kind, however, would probably aggression is expensive. Even a small theft or destruction can quickly pile up a fairly large debt when related expenses, secondary payments, and others who suffered because of this victim's loss, costs of defense and arbitration, etc., are taken into account. In a totally free society, men tend to be financially successful according to their merit. Few successful men would desire to commit aggression. Few unsuccessful men could afford to make immediate payments for it. Assuming the aggressor could not make immediate payment of his entire debt, the method used to collect it would depend on the amount involved. The nature of the aggression, the aggressor's past record and present attitude, and any other pertinent variables will be taken into account. Several approaches suggest themselves. If the aggression were not of a violent nature, then the aggressor had a record of trustworthiness, it might be sufficient to leave him free and arrange a regular schedule of payments, just as it would be done for any ordinary debt. If the aggressor could not be trusted to make regular payments, a voluntary agreement could be made between the insurance company, the aggressor, and his employer, whereby the employer would be compensated for deducing the reparations payment from the aggressor's earning each pay period. If the aggressor were unable to find or hold a job because his employers were unwilling to risk hiring him, he might have to seek employment from a company which made a practice of accepting untrustworthy workers from lower than market wages at lower than market wages. If the facts indicated that aggressors was of an untrustworthy or violent nature, he would have to work off his debt while under some degree of confinement. The confinement would be provided by rectification companies, firms specializing in this field, who would maintain debtors' workhouses. The use of term prison is avoided here because of the connotations of value destruction attached to it. The labor of men confined would be furnished to any companies seeking assured sources of labor, either by locating the debtors' workhouses adjacent to their plants or by transporting the debtors to work each day. The debtors would work on jobs for wages, just as would ordinary employees, but the largest part of their earnings would be used to make reparations payment, with most of their rest going for their room and board, maintenance of the premises, guards, etc. To ensure against refusal to work, the reparations payments would be deducted from each pay before room and board costs, so that if the man refused to work, he would not eat, or at most would eat only a minimal diet. There would be varying degrees of confinement to fit various cases. Many debtor workhouses might provide a very minimum amount of security, such as do the few present-day prison farms where inmates are told, there are no fences to keep you here. However, if you run away when you are caught, you will not be allowed to come back here, but you will be sent to a regular prison instead. Such workhouses would give debtor a weekly allowance out of his pay, with opportunities to buy small luxuries or perhaps rent a better room, weekend passes to visit families and friends, and even more extended vacations might be arranged for those who have proved themselves sufficiently trustworthy. Other workhouses would provide facilities of greater security, ranging up to maximum security for individuals who have proved themselves extremely violent and dangerous. A man whose action had forced his confinement in such a workhouse would find himself at a disadvantage in several ways. He would find that he had less liberty, less luxuries, limited job opportunities, and a longer period of confinement, because with more of his earnings spent on guards and security facilities, it would take him longer to pay off his debt. End quote. So, so traditional prisons are improbable in a free society because of a few economic reasons. First is that there is jurisprudential risk involved. Unlike the state police or courts, these private entities have no special privilege or immunity. The concept of immunity does not exist. Every individual in a private law system is responsible for his own action, and this extends to the collective, like this extends to any collective, like a defense agency. An agency will be responsible for incorrect judgment of guilt, and it will be liable for the now victim that it thought it was a criminal. Other agencies would gladly enforce this liability in a competitive environment. Second reason why I think that a free society won't have traditional prison is that they are costly to maintain. The only reason the revenge-based prison system survives is because of tax money. Running a traditional prison isn't exactly profitable business on a free market. The only reason why we have a sort of private prisons currently uh, is because they are paid by the government to provide those prisons. While debtor warehouses can be a profitable business because you're providing a service that even the criminal debtors may want. Criminals who wish to work off their debt and want a fair chance at rehabilitation would easily want the services of a debtor warehouse. While they are working off their debt, they would be paying the warehouse for a variety of services like housing, food, and probably rehabilitation, which may involve 24/7 surveillance and psychiatric treatment, and maybe a certificate in the end, so that he can start building some trust with other members of the society. So because the insurance company would want to recover its losses quickly, it may even spend money on increasing the productivity of the debt worker. The insurance company's desire for speedy repayment would be the debtor's best guarantee against mistreatment. Earning power depends. Earning power of a worker depends on productivity, and productivity depends on the use of mind. But a man who is physically mistreated and mentally abused will be unwilling and even unable to use his mind effectively. A mistreated man is good for little more than brute physical labor, a situation of prohibitively low productivity. It might seem utopian, but it is not unprofitable. Of course, we are talking about a well-developed restitution-based justice system that has the liberty to develop these luxuries like rehabilitation. At the nascent stage of a free society, we may see some primitive form of this system. So, so why does the state not take the path of restitution and instead chooses the eye for an eye kind of system? Uh, this has something to do with the fallacy of crime against society. From the chapter, I'll read from the chapter. The fallacy is the assumption that society is a living entity and that Therefore, a crime can be committed against it. A society is no more than the sum of all the individual persons of which it is composed. It can have no existence apart from or in contradistinction to those individual persons. A crime is always committed against one or more person. A crime cannot be committed against that amorphous non-entity known as society. Since neither society nor government can have any rational interest in bringing a specific aggressor to justice, who is interested? Obviously the victim, and secondarily those to whom the victim's welfare is of value, such as his family, friends, and business associates. According to the principle of justice, those who have suffered the loss from an aggressive act should be compensated at the aggressor's expense, and therefore it is those who have suffered the loss who have an interest in seeing the aggressor brought to justice. End quote. Okay, so Andrew, you ask how are labor rates of captive labor force determined? Usual market patterns do not apply. L- Laborer has no real ability to. Uh, I didn't quite get the question, Andrew. Can you like elaborate?
Well, I mean, if you have laborers being forced to pay off a debt they owe, um, how is the labor rate determined? Can't the businesses simply decide that the labor rate is 10 cents a day and
Oh,
nobody
nobody has
you'll
the
never pay
ability
it
to
off,
defend
so
him.
you'll basically have an endless
Yeah.
supply of slave labor.
No, but it's actually it's the slightly the other way around. As I tried to explain, debtor workhouses actually have both the insurance company and the debtor as his how to put it as his customer. So you're asking what will protect a debtor worker.
How does a worker
Like
push
how does
back and
someone
say,
even how does someone even bargain and set a price? Well, how it has been explained in the book is that the aim is not to put worker in a workhouse and make him work. The aim is to declare him under debt, and the punishment for him is not working in a debtor warehouse. The punishment for him is giving those making those payments to the said insurance company. So. So it is his it's like him trying to he will have to end up paying that debt regardless of whether he's in a debtor warehouse or he's working on his own. If he can
so
find
it's a bargaining
so
between
yes so
the
it's
company
basically
hiring and the
and the debtor actually. So
right. So
yeah, so
basically,
if
the labor has no input to it.
uh, bargaining between the company and the what are we talking about?
And the laborer. I mean, the company would bargain with the insurance company. Insurance company wants the debt to be paid off as quickly and easily as possible. The people, giving the job want, of course, the lowest wage rate possible.
Well,
The negotiation is between these two entities, and the actual laborer doesn't have any say in the matter. Is this the way it's being set up?
This is not the way that I saw. Definitely, forced labor would be against the principles of free market. That is not what they advocate. The responsibility to pay off debt, the debt that the aggressor has created, is on the aggressor. How he pays it back, how he earns it, whether he sells his property, existing possessions, or how he does it is depends upon him. And if he's able to do it, a workhouse will not even be involved. But and if he's able to get a job to work and pay off that debt, and maybe in non-violent, maybe in uh, in cases which are not exactly criminal cases, but violations of contract and such stuff like that, there won't be even need for such a debtor warehouse. In which case the person will have to work off his debt. He'll just have to find a job on the free market somewhere where he could earn. The situation of debtor warehouse actually arises, from what I understand from Tannehill, their writing, is that when the debtor is unable to find a job anywhere, when no employer is willing to employ a particular no employer is willing to employ that particular offender, because he's either a violent offender who has done something that was really heinous, or for some reason no one is really trusting that person, because we find that criminals usually do have a hard time finding a good job. So it's not that someone is forcibly taking him and putting him in a debtor warehouse and saying to him that you have to work here and nowhere else. What anyone is only doing is that you have to pay this much debt off. How you earn is upon you, and here are these some particular debtor warehouses where you can check yourself in and work on rehabilitation and stuff like that. And basically, so here the debtor, the aggressive, the worker has the option of either checking him into the labor camp, or choosing between multiple the debtor warehouses, or not getting into a debtor warehouse and taking responsibility for himself and finding a job somewhere if he can to pay off that debt.
Well, then what would stop him from simply just walking away from the warehouse and said, "I'll pay it back later when I feel like it"?
That what is stopping the same thing that is stopping any other debtor. I mean, the only difference between him and any other debtor is that he has committed a crime. And so what is stopping in the free market, what is stopping me from taking a huge amount of loan from you and simply walking away and saying that, I will pay you later when I feel like it. So
because you get thrown in jail.
Well, yeah, it could get you thrown in jail, or or it could, in this kind of system, the force could be used to extract all your property that you have currently.
So if you don't have any,
recover. So if you don't have any, then it becomes a question of putting someone in a debtor warehouse. Yes, and here
and their incentive to work is what exactly?
To pay off the debt. Yeah, I don't.
Well, they don't care about the debt. They wouldn't have incurred it in the first place.
So if someone has no incentive to work, he'll be.
They're not going to work.
Put in confinement. I don't know how it will go. I mean, like, people who have given up on society like that, I don't know if there's any way to deal with them. I don't know how the state deals with them by putting them in jail. I'm not sure how the free society would deal with it. I mean, like, just putting them in jail and just putting them there.
Actually, if you don't have anything, you wouldn't get a loan from anyone.
But if you don't care, you already got your loan.
I mean, this is a situation, right, in which a loan is it's a theoretical loan. It's not exactly given. It's a restitutive loan.
I think, anyways, you have to, like, a person, a criminal who is, unwilling to pay his debt, you have to use force. So force, the justification of force comes in, like, when somebody has violated any other, there is a victim involved. So we have to force the criminal to, to compensate the victim somehow. So I think even if there are jails or, warehouses where criminals are supposed to work, there will be different warehouses. Somebody, some warehouses will have certain kind of jobs, and other warehouses might have certain kind of jobs, different labor rates. So I think there will be some kind of salary fixation, and the insurance company and the private police who has the power of arrest are going to put this person in that particular warehouse, and there has to be some kind of force. It cannot be that without.
Ultimately, if like no one is, if the aggressor is just has the attitude that do whatever you want, I'm doing nothing, I'm not following no rules, I'll not be cooperating, I'll be just sitting and doing nothing. Well, in that case, well,
There is no
at the end of the day,
daily.
I think there's no other alternative. Whether it's the state or some market institution, ultimately, force will be used to extract as much restitution as humanly possible. I mean, he has created a debt, but you can't extract that which he doesn't have. Neither can state nor can a market institution.
Now, I have to ask, I'm sort of new to these ideas, so I'd have to ask just a couple of questions just so it can be clear in my own mind. I hope you don't mind.
Yeah.
One is it says every dispute is between an aggressor and a victim, but there are honest disputes in which there are no aggressors and there are no victims.
Yeah, of course. Yeah.
Where is the borderline between my property and my neighbor's property? They think it's one place, I think it's another. There's no aggressor and victim here, but
Yeah,
we want to know because we want to put up fences, So that's
Yeah.
a dispute. There's no aggressor, there's no victim.
This is the starting point of the paper. I think we'll discuss it in a couple of next podcasts. The justice entrepreneurship in a free market. He
They
talks
just
about
make it's just a statement that a dispute is between a victim.
Yeah, so
but you can have disputes that are not between victims and aggressors.
no, but like how you're interpreting is that when you're talking about dispute between the victim and the aggressor, you're assuming you know who the victim and the aggressor is. If you know who the victim and the aggressor is, I don't think there's any matter of arbitration. It's only when the victim is extracting a lot more from the aggressor than would be considered justice is when arbitration starts to come in. So if the matter is already clear, I don't think arbitration would even be involved in a lot of these cases. Arbitration is only involved when the matter is not clear, when the two people cannot sit together and decide what exactly is. If there's an aggressor, it becomes a matter of private defense. If someone is attacking you, you're not going to wait for an arbitrator is not even involved. It's only it will be a matter of private defense. You'll have to defend yourself. The arbitrator only comes in when there's a dispute between two parties and they are willing to settle. As you said, that there could be disputes, honest disputes between two parties, and the function of an arbitrator does not really change whether it's an honest dispute or if it's not an
Yeah,
honest dispute.
even in the honest dispute, there will be justification, right? Because there will be claims involved. Like I claim this property, and this is
So
what.
even in suppose I have a tie, I have a car basically, and you suddenly out of the blue come and hey, you come to me and say, hey, this is my car. You probably stole it from me. So now we have a dispute, and you might not even be a person who is claiming it out of thin air. You might really think that I have your car because my car looks exactly like yours. But the fact is, I think this is my car, and you think that this is your car, and now there's a dispute. Now there needs to be someone needs to go to the bottom of it, find the source of the purchase of this car, and to prove who the car really belongs to. And in such cases, between agencies, there can be a dispute. The proof might not be clear. In such cases, also arbitration would be required. So at the end of arbitration, if it turns out that it was my car and not yours, at the end of the day, neither of us are really aggressors, but the dispute still happened, and the agency still got involved, and so did the arbitrator. So in such a situation, so it's not necessarily we talk about aggressor and victim, but we are assuming that we know that at the end of the dispute there will be an aggressor and there will be a victim, and there isn't. That is also a possibility. Basically, the aim is peaceful resolution.
See, the other kind of honest dispute would be property disputes where the previous property owner had died. For example, an elder in big family with a lot of relatives staying under one roof, joint families kind of thing. If the owner, who is the current owner, especially it's mostly the elder of the family, if he is dead and his heirs are disputing on the property, like how much who should get and what if one person has done for the family and stuff like that, right? That's a dispute, like who gets what. It's a joint ownership kind of on the property. Or it might be a company where two partners want to split at certain point of time and they have a dispute of how much share should go to whom and what. Now here we don't have a victim, we don't have an aggressor, but we have a dispute of who gets how much. So even that will go to the arbitrage, and I think they have to claim like why they demand what they are demanding. And again, that I don't think here there will be a use of force, like the dispute will stay open until and unless there is no settlement. So that's the only way I think such kind of disputes will be sorted out. Otherwise, I don't think there will be there has to be jail, or there has to be forceful distribution of wealth or resources. It has to be it has to go on till settlement, I think.
Yeah, it was because when doing the reading, it seemed that was the definition of a dispute. Whenever there's a dispute, there's an aggressor. And this is just not the case.
Yeah, I mean, because we usually talk about crime, right? So we're automatically putting it in context of crime, because people usually don't have a problem thinking about dispute resolution when neither of us are violent. But people have issues dealing with dispute resolution when one party is obviously the violent criminal. How are we going to survive without the state? And that is where the discussion actually ends up being. So our language has, I think, naturally mirrored that.
I'm not trying to defend the state at all. I'm just trying to understand a little better.
I think the role of arbitrator ultimately comes in when there are conflicting property rights claims. So it could be an honest mistake on both sides, or it could be one person is being dishonest. But in either case, the role of detective agencies and the role of arbitration doesn't really change, because before taking the case, both the detective agencies and the arbitration agencies don't really know whether someone is being honest or dishonest. That is why they have to go through the procedure of the entire court trial.
Another question: how do you deal with loaners? For example, if
sorry, I didn't get that.
How do loaners, people who are off by themselves, people who have no living relatives, no known friends, is it okay to just go up and kill them, because once they're dead, there's nobody to recompense?
One paragraph that I copied from later, and how. So yeah, the question of loaners. So when I reach there, I'll probably have the context in my mind to answer that question. So can we defer it for a few half an hour or something?
I'm just trying to get to this definition.
Yeah.
Okay.
So
whenever you feel like it.
So basically, I think the argument is that what if I have no family, no job, no contact, nobody really cares about me, and someone kills me? Who is going to ultimately come and demand justice from me? That question, we get to that question. This has been dealt somewhere later. Shikhar, I have to mute you. There's background noise. Anyway, so I'll move forward. Yeah, Shikhar.
What would be the incentive against? I mean, like there are mafias operating who are hired killers, so that's a much more violent kind of a thing existing. But what I'm asking is, there are people who would have an interest in extending the dispute as much as possible. So what would be the incentive against maximum extension attempts of disputes? I mean, some underground things like deception agencies kind of might pop up, so that they help the parties, certain wealthier parties who would like to extend the dispute as much as possible.
You're talking about in case of arbitration, or you're talking about in case of mafia? Because if a mafia has truly gone violent, it won't be ready for an arbitration, right? So which of the two are you asking? So you're saying that what if someone wants to prolong the arbitration case? Is that what you're saying? Okay, yeah, so that is also there in my text. I'll just read on when I get there, because actually I've written down the speech, right? So I put all the points I could find and put it. So it's also there. When I get to it, I'll also answer that. So just hang on.
Okay.
Uh, okay, so so I'll continue. Believing that crime has been committed against society rather than some individuals is taking away private responsibility for punishment. When we say that crimes against society are to be punished by the government, we give up all the private responsibility of punishing the criminal. Uh, the aim of the government is not the government is primarily not concerned about the victim, because only individuals can show concern and only individuals can act. The motives therefore become political. The government is able to hide its actions behind the immunity of law. What I mean by that is, even though the government claims to follow proper procedure and treat people as innocent until guilty, we find that the reverse is true. If the government arrests you, detains you, or ill treats you, it is not made to submit to an external third party agency and punished for its wrong decisions. You are not compensated for your time in prison, which we now know was an act of kidnapping. On rare occasions, suppose the government does pay you, that money comes from the pockets of the no, comes not from the pockets of aggressors who actually detained you, but from tax. Really, the government is economically the most unaccountable institution. It loses nothing for its bad decisions. This is true for its acts of interference in other sectors of the market. Why would it not be true for its accountability in implementing the law? A private agency, on the other hand, would not dare arrest you or detain you unless it was sure that a disinterested third party would pass judgment in its favor. If a private agency does not have enough evidence to win a case, it won't act, because if it loses the case, it had kidnapped an innocent citizen and must pay restitution to him. Now, I'm not saying that private agencies will make no mistakes, but in a system of private responsibility, therefore, there forms a system of checks and balances that punish bad jurisprudential decisions and rewards the good ones. Such a mechanism is missing for the government. I think one major reason that people have apprehensions against the system of private law is that they are still in the mindset of state justice, that justice can only be provided by someone in permanent authority, that we need a permanent hierarchical structure that is capable of delivering justice. Before understanding private law, this mindset must be abandoned. What market anarchists show is that such a mindset is destructive to the very concept of justice. When people with such mindset analyze a private law society, they immediately imagine corporations with as much immunity as the state. That is not what is being argued here. What is being argued for is equality of authority. If the agency in a private law society detains someone, it is it is not doing so because it has the right to do so. The agency will have to justify its actions just like the rest of us, or be declared a criminal and hunted down. When a state detains someone, it is considered to be a proper procedure. There is little to no physical backlash against the state. The state is immune to external checks and balances. Its notion of innocent until proven guilty is a lie. In reality, justice requires neither presumption. What it requires is private responsibility. If you think someone is guilty of a crime, you must be really sure of the fact before you go ahead and detain him. A guard in a government prison can treat the prisoners as less than animals and never be brought to account for it, because he is protected by his status as a part of policing arm of the government. If a guard in a debtor's workhouse couldn't, but a guard in a debtor's workhouse couldn't hide behind the skirts of a rectification company which employed him. The way the prison guard hides behind the skirts of the government, the debtor workhouses guards would be recognized as an individual responsible for his own actions. If he mistreated a debtor, in his custody, he would be held personally responsible. If he couldn't wriggle out of it by putting the blame on the system. We will discuss the concept of private responsibility and entrepreneurship in a free market justice system when we discuss the paper Justice Entrepreneurship in a Free Society. There's more of this on this topic, but I think for now this will suffice. So the mechanism that Morris and Linda Tannehill explain is quite similar to what was discussed in the previous podcast based on the writings of Rothbard and Friedman. So I'm just going to discuss some additional insights. So the Tannehills have a concept of secondary losses. For example, when a man is assaulted and seriously injured, his family may be caused expense as well as anxiety. If he is a key man in his business, his employer or his partners or his company may suffer financial loss. All this destruction of value is a direct result of irrational behavior of the aggressor, and since actions do have consequences, the aggressor has the responsibility of making reparations for these secondary losses as well as the primary loss suffered by the victim. Now, I don't know if this concept gels with the Rothbardian ethics, but one could consider that it is up to the victim to decide how the reparations payments can be distributed. This is one of those times when market can be unpredictable as far as libertarianism is concerned. Whether or not you advocate secondary reparations, they are likely to occur if some conditions are true. Firstly, if the expected reparations payment must be more than the cost of being involved in the litigation. Second, the total amount of reparations which can be collected is limited by the aggressor's ability to pay, and of course the first consideration goes to the victim, so you might not even be able to extract any reparations if you suffered secondary losses. Now, next, let's talk about what would be restitutive amount and what market forces decide the restitutive amount. Rothbard had this notion of double restitution, that the aggressor must not only replace or pay for the damaged property, but also pay an equivalent amount more. This sounds a lot like price fixing and seems quite unlike Rothbard. Market mechanism will have various economic forces deciding the restitution amount, and they need not be double. If in some cases the amount may even be more than double. If suppose I have stolen 10 rupees, which is a small amount. Now, how can so now how much of restitution can you demand? Obviously, you cannot demand 1,000 rupees from me, but in certain situations it would be justifiable. What if I was saving those 10 rupees for a business opportunity that I missed because of your theft, and I lost that investment opportunity to earn a lot more? Let us consider a worse situation. What if you were taking a bag full of cash to a hospital to pay for an operation of a relative? If you were robbed by me, it could very well prove fatal to the life of your relative. In such a case, there is no telling how high the restitution amount will be. It certainly would be more than double. The more psychic loss you have suffered, higher the restitutive amount you're going to demand. There is no way to directly measure your psychic cost. In many situations, it might even be considered philosophically unmeasurable. If you lose something of irreplaceable value, you might even demand revenge instead of justice. The market, being amoral, would probably provide it if there is enough demand for it. However, justice requires the aggressor to compensate the victim insofar as humanly possible, and replacing something of irreplaceable value is impossible. Certainly, we can't expect justice system to do the impossible. So this was one side of the market forces. People who want justice would demand restitution payments, and they will demand a certain value which they would consider to be enough compensation. But what stops them from demanding irrationally high price for even petty violations? First of all, restitution amount cannot be so high that the aggressor loses his interest in even paying for it. Remember, the reason why he wishes to accept this restitution debt is because he either he wishes to rejoin civilization and regain his reputation, or he's afraid that the retaliation would make life uncomfortable and maybe even impossible. If restitution amount that the victim demands, or the victim's agency's demands, is too high, he might even lose that interest. Like if it's so high that he has to work his entire life and he still won't be able to pay it. This is why we have so many criminal fugitives. The state justice system offers nothing to the criminal, no chance at redemption or rehabilitation, and the justice that the state imposes appears to be so unjust that being a fugitive seems like a rational thing to do. So restitution amount would not tend to be irrationally high because it would not be in the best interest of the victim. If the criminal decides to be a fugitive, the victim will get no restitution. But what if the situation arises where the criminal thinks that the restitution amount demanded by the victim is really high, or that the detective agency did some frivolous expenditure to actually capture him and is simply passing the expenses on to him? Does he only have two options, pay the restitution or become a fugitive? Certainly him becoming a fugitive is not something both parties want, unless the criminal is incorrigible, in which case it's a matter of show of strength, and in anarchy such threats will be neutralized with minimum fuss. But is there no way for criminal to participate in this process and still not be subjected to irrationally high punishment? This is where the competition comes in. In matter of state, no one has the right to contest a state court's decision except an even higher state court. But the judgment of anyone in market anarchy can be contested by anyone, and there is no legal immunity. And there is so if the criminal thinks that his punishment is disproportionate to his crime, he certainly has other agencies he can turn to, in which case a dispute will exist between the criminal and the victim. Only now is arbitration needed. If the criminal had accepted the demands of the victim and his insurance agency, the matter would have been settled and there would have been no need for an arbitration agency involved. And therefore no cost of arbitration would be involved either. This leads to another interesting conclusion, that because an arbitrator costs money and the loser of the trial would have to foot the bill, in this situation there is no incentive to prolong a trial or to make frivolous cases. If the criminal knows he has no case and knows that he cannot convince the jury that his crime is disproportionate, then he would not likely he's not likely to file a case, because if he loses the case, his monetary losses would increase. Same is true for other side. The victim or his agency is less likely to demand an irrationally high punishment if they know that they are going to lose in arbitration and will have to pay for the arbitrator's service. Instead of gaining a high profit from restitution, the agency will end up losing a small amount of money to the arbitration agency. This way, everybody has an incentive to not file frivolous cases and to not prolong the case. Longer the case, more is the arbitration fees, and the more the loser has to pay. And in most of the cases, it is the loser, the person who expects to lose, that prolongs a trial. Compare this to the state court system, which actually incentivizes frivolous cases and allows cases to prolong because of their inability to calculate cost of arbitration, precisely due to the lack of competition and tax funding. Furthermore, the hierarchical structure of the state court system becomes merely a bottleneck for the justice system to actually reach the victims. While in market justice system there is an incentive for a speedy trial, and every case is on a fast track because there is private money involved in prolonging the case rather than public money, which no one is accountable for. People usually try to say this the other way around, that we need a hierarchical court system because there needs to be a final arbitrator. But such a term is a misnomer when one considers that litigation costs money that the loser has to pay. So there will always be a final arbitrator, and cases will not prolong forever. It is just that there would never be a single final arbitrator. Others say that if the victim and the criminal are unable to agree on an arbitrator, we need a final arbitrator that must be imposed on them so that peaceful resolution can happen. But this could only be called peaceful resolution in a very corrupted sense. Arbitration occurs when the two parties are in conflict and are ready to settle. If one party is ready for arbitration and the other is not, then no mythical authority of a final arbitrator will be able to get them to sit and talk. In such a situation, physical conflict would be impossible to avoid. What really would stop a war from breaking out would be retaliatory force, and there is no reason to believe that such retaliatory force